Hello friends, in the series on the income tax cases, we will discuss an issue which is based on section 127. Section 127 talks about power of transfer of cases. The issue before Delhi High Court in this writ petition was that if any decentralization of the cases is being done without bringing on record the transfer order under section 127, then in that case, only on the basis of some CBDT notification which says that the assessing officer who passed the assessment order has the inherent jurisdiction over the assessee can be passed. This issue has been taken by Delhi High Court in the case of Raj Sheela Growth Fund Private Limited versus Income Tax Officer, and this case has been reported in 466 ITR at page number 26. The date of the judgment is 8th May 2024. The facts of the case are like this. In this case, the assessee's original jurisdiction was Ward 21-1. The cases of the assessee were centralized to the Central Circle 16, which later on became Central Circle 20. The assessment was completed there, and then after that the decentralization of the cases was done and the assessee case was transferred to again Ward 21-1, and that assessing officer, that is Ward 21-1, passed the assessment order for the assessment year 14-15 and 15-16. When these assessments were made, the matter went to the CIT appeal and then tribunal, and at the level of tribunal, the assessee raised the question of jurisdictional ground, in the sense that the assessee took the ground that the decentralization was done without the order under section 127, and hence all the assessments are bad in law. The tribunal remanded the matter back to the AO to verify that whether there is 127 order or not, but the assessing officer again proceeded to pass the assessment order without bringing on record that whether there is section 127 transfer order. So the assessee challenged this matter in the writ court, and the Delhi High Court said that in the present case, the revenue was relying on the order dated 15th November 2014, passed under section 120 by the Assistant Commissioner of Income Tax, read with Central Board of Direct Taxes notification dated 22nd October 2014, and the revenue was pleading that this both the notification gives the inherent jurisdiction to the assessing officer of Ward 21-1 over the assessee. When this matter was heard by High Court, the High Court held that such a situation could not be countenanced in law, as it could lead to confusion and chaos, since at one point of time not only there will be two assessing officers of the assessee, at the same time they can proceed simultaneously over the assessment proceedings, and such a situation cannot be countenanced in law. Delhi High Court also said that the Central Board of Direct Taxes notification could not run contrary to the legislative mandate of section 127, and hence Delhi High Court quashed the assessment order, and simultaneously all the orders passed by tribunal for the assessment year 14-15 and 15-16. Friends, in this case, the tax amount involved was very huge, and the department lost its case just because of the technical glitch that they do not have the 127 order. So it shows that how important the procedures are, how important the administrative acts are. But at the end of this case, the High Court said that since the assessments have been quashed on jurisdictional ground, so if Otherwise, the law permits the revenue can proceed with the matter by issuing the fresh notices. At the end of this video, once again, I am repeating the name of the case. The name of the case is Raj Shila Growth Fund Private Limited versus Income Tax Officer, and this case has been reported in 466 ITR at page number 26. The matter has been decided by Delhi High Court and the date of the judgment is 8th May 2024. Thank you, friends.